Good morning, everyone. Hope everyone's doing well today.
Good morning, Your Honor.
Morning.
Morning.
Doug, did you receive all your paperwork?
I did. Thank you, Ms. Lewis. I greatly appreciate it.
Welcome.
And as soon as courtroom 2 is ready, we'll be ready to start.
Good morning, Your Honor. How you doing?
Good morning. I'm well. How are you, Norris?
Wonderful, sir. Wonderful. We're gonna start
Good.
with James Bell, position number 7.
Number 7. Okay, thank you. And this is going to be a negotiated plea, Mr. Dodes?
Good morning, Your Honor. Yes, it will be a negotiated plea.
Good morning. Thank you. Good morning, Mr. Bell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Mr. Bell? Okay. We're doing this by,
Listen. He's asking if you agree to have your case heard by video.
I hear you, sir.
okay, thank you. Can you raise your right hand for me, Mr. Bell?
What now, sir?
Can you raise your right hand for me?
On right hand?
Yes, sir. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down, Mr. Bell. Thank you. Good morning, Mr. Walker.
Good morning, Your Honor. How are you?
I'm doing well, thank you.
The state's recommendation is 12 months to serve, 32 days. Credit for time served, 16 days, balance suspended with the condition of a stay away from all of Georgia Tech's campus. He has permanently been banned from the campus in the past, Your Honor.
All right. Mr. Douglas? You are mute.
Apologies, Your Honor. Yes, that's our understanding of the offer. I would request that it be worded as serving 28 days, credit for 14 days. Mr. Bell has, based on my math, has credit for 14 days. And it seems in the spirit of the deal, it was a time served offer. So we would ask for it to be reworded as serve 28, credit for 14 days.
There's no issue with that, Your Honor.
Okay, very good.
Thank you. And we stipulate to the factual basis, venue, and ID for the purpose of the plea.
Mr. Bell, it's my understanding that in case 23 CR 0009622Y, you wish to plead guilty to criminal trespass. Is that right?
No.
Is that a yes?
No, yes, sir.
Thank you. Are you under the influence of any drugs or alcohol this morning?
What, sir?
Are you under the influence of any drugs or alcohol?
Do alcohol? Yes, yeah, sometimes, yeah.
He's asking right now.
Yeah.
You're not under the influence of any drugs or any alcohol, are you, Mr. Bell?
Look,
Does he understand my question, Mr. Dodes?
Yes, Your Honor. He said no. I don't. You need to speak into the microphone, Mr. Bell.
no, sir.
Okay, you've been represented by your counsel there. Are you satisfied with what he's done for you?
I quite hear you then, sir. So what now?
You've been represented by your counsel who's sitting beside you. Are you happy with what he's done for you?
No, I know.
You're not, are you happy with what Mr. Dodes has helped you with regarding this charge?
Can you understand the
I
question?
didn't quite hear him.
What's your, do you have a good ear? I know Mr. Bell has trouble hearing. Do you have a good ear
Okay.
to lean into?
Now, what?
What's your good hearing side?
Was I hear the side?
Yeah, do you have a better ear? Can you lean into the speaker to hear the judge?
Your Honor, can you say it one more time, please?
I can. Mr. Hill, are you happy with what Mr. Dodes has done for you in this case?
Oh, no, sir, no.
That's a yes? Okay. You understand that you have a right to a trial by jury, and by pleading guilty, you're giving up that right to a trial by jury. You understand that?
Yes, sir.
Has anybody forced you to plead guilty?
No.
Okay, I'm going to accept your plea as negotiated, Mr. Bell. You know you can't go back to the Georgia Tech campus, okay?
All right.
Okay, good luck, Mr. Bell.
He must have gone.
And Your Honor, I do see Mr. Deneen Ray, who is the father of Zafar Antoine, position 3. I just want the court to be aware that he is here as family support. I don't know when we're going to get to Mr. Antoine's case, but I did want to note that.
Okay, thank you. If you will remind me again, once we get to that case, I'd appreciate it.
Your Honor, I checked in Odyssey, you're saying that he's in Grady, that he went to Grady, he was a loan out to Grady.
I saw
Oh,
that
okay.
as well.
So, and that's Mr. Antoine, position 3?
Yes, Your Honor. I spoke with him yesterday. I wasn't aware of the Grady Holt loan today, but
Okay, you want to put this on Tuesday's calendar?
yes, and Mr. Ray, I'll give you a call after court to go over that. If we could please put that on Tuesday's calendar.
Okay, so Mr. Ray, since Mr. Antoine is at Grady, we're gonna reschedule this for the SAP calendar on next Tuesday, okay? You're on mute if you're speaking to the court, Mr. Ray.
All right, Your Honor.
Okay, very good. Thank you. Have a good day, sir.
You as well.
Thank you. Who do we have next?
Next, we have position number 8 and position number 9, Mr. Octavius Benson.
This is going to be a negotiated plea and a null process.
Yes, Your Honor.
Good morning, Mr. Benson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Benson. Mr. Walker?
Yes, Your Honor. It's simply time served 82 days. No conditions.
Okay. Anything further, Mr. Godes?
Nothing further, Your Honor. We stipulate to the factual basis, venue, and ID for the purpose of this plea.
Mr. Benson, it's my understanding that in case 22 CR 003097Y, you wish to plead guilty to driving while your license was suspended or revoked and failure to obey a traffic signal or light. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Benson. Good luck to you, sir.
Thank you, Mr. Johnson. Did I get a print already, sir?
I can send you one.
Next, we have position number 13, Mr. Eddie Dickerson Jr. Okay.
What's the announcement on Mr. Dickerson?
Yes, Your Honor. I met with my client yesterday and went over all of his options as well as his case to the best of my knowledge, and he wanted to wait till today. He has indicated that he wants to go forward with the negotiated plea. Is that correct, Mr. Dickerson?
Yes, Your Honor.
Okay, very good. Mr. Dickerson, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, yes, sir.
Good morning, Mr. Dickerson. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Mr. Walker?
Yes, Your Honor. The state's recommendation is 12 months to serve, 60 days, credit for time served, 16 days, balance probated with a 6-week anger management course. Also, the condition of a behavioral health evaluation with any necessary treatment and to remain compliant with any and all MARTA suspensions.
Yes, Mr. Dodes?
Yes, Your Honor. That's our understanding of the offer. We would request this court to waive Mr. Dickerson's probation fees to help him get on his feet. And upon completion of all conditions, if we could switch him over to non-reporting status.
Any objection to non-reporting?
No objection, Your Honor.
Mr. Dickerson, it's my understanding that in case 23 CR 000970E, you wish to plead guilty to 2 counts of willful obstruction of a law enforcement officer and battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Dickerson. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir. Thank you.
All right, very good to you, Mr. Dickerson. Good luck to you, sir.
Thank you as well.
Thank you.
Next, Your Honor, we have position number 15, Mr. Mark Harwell.
And Your Honor, I received Mr. Harwell is also on the add-on calendar. If we could just go on mute so I could relay the offer for his second case to him quickly to see.
Okay, just let me know when you're ready to proceed.
Thank you, Your Honor. We're ready on positions 15 and add-on 4.
Okay, and what's the announcement for add-on 4?
For 4, it will be a negotiated plea.
Okay. Good morning, Mr. Harwell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Good morning, Ms. Campbell.
Good morning, Your Honor. The recommendation on position 15 is going to be 12 months to serve 28 days. Credit for the time he's already served 14 days. The balance is to be suspended and he's to stay away from the incident location, which is 2370 Metropolitan Parkway. As to add-on position 4, I believe that might be Mr. Walker's case.
It is, Your Honor, and it's going to be 12 months to serve 6 days, credit for time served 3 days, balance probated with the condition of a behavioral health evaluation, any necessary treatment, and to stay away from that same incident location, 2370 Metropolitan Parkway.
Hey, any objection to non-reporting once he completes the terms?
No objection.
Yes, Mr. Dodos?
Yes, Your Honor, I conveyed that to my client and he's willing to accept that. In addition to non-reporting, we'd ask for his probation fees to be waived so we can get back on his feet. And we stipulated the factual basis, venue and ID for the purpose of this plea.
Okay. Mr. Harwell, it's my understanding that in case 23 CR 000969J, you wish to plead guilty to criminal trespass, and in case 22 CR 008090J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the pleas as negotiated, Mr. Harwell. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Harwell.
Thank you, sir.
Let's start with the program.
Next, Your Honor, we have position number 20, Mr. Morris Mallard.
How you doing, Mr. Mallard?
This is also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Mallard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Thank you. Can you raise your right hand for me, Mr. Mallard? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
Okay, you can put your hand down. Thank you, sir. Ms. Campbell?
Yes, Your Honor. The state's recommendation for Mr. Mallard is going to be 12 months to serve 22 days. Credit for the time he's already served 11 days, and the balance is to be suspended. Nothing further.
Mr. Dodes?
Yes, Your Honor, that's our understanding of the offer. We stipulate the factual basis, venue, and ID for the purpose of this plea.
Mr. Mallard, it's my understanding that in case 17 CR 021737F, you wish to plead guilty to suspended or revoked license and failure to obey a traffic sign, signal, and markings. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Mallard. Good luck to you, sir.
Thank you.
Next, Your Honor, we have position number 10, Darrell Burns.
And this is going to be an arraignment.
Yes, Your Honor, we're going to waive formal arraignment.
Okay, and you're gonna file a waiver,
Yes, Your Honor, and I'll send that as soon as we get out of here.
okay? And I have down that you also want to address the issue of bond.
Yes, Your Honor.
Okay. Since, let me get the who do we have on from pretrial this morning?
Good morning, Your Honor.
Good morning, Ms. Jackson. Does Mr. Burns have a history?
The defendant has 4 cycles. The defendant's last arrest was July 6, 2016 in Tennessee for driving while license suspended or revoked. There was no disposition for that arrest. There were no convictions listed in the GCIC, Your Honor. Nothing in addition.
And what's his current bond, Mr. Walker?
On the simple battery, Your Honor, it is $7,000 surety. I'm sorry, on the simple assault family violence, it's $7,000 surety. On the 2 simple batteries, $1,500 surety on each count. So in total, that's a $10,000 surety. On 2/15/23, the victim is, sorry if I'm mispronouncing the name, Fontillas was walking to the bus stop to get her son. Upon arriving at the bus stop, she was met by the defendant. The defendant then proceeded to follow her and her son home. He did threaten her and her son. He did also pull out a firearm and proceed to rack the black firearm. As she was trying to walk away, he did grab her son, Geronte Irby, by the arm. At this time, I believe the defendant did disappear from the location. At this time, the victim proceeded to walk to the daycare to pick up another one of her children, and the defendant reappeared, pulled out the same firearm, and re-racked the firearm yet again. And this time, he grabbed her son, Devin Irby, by the arm. At that time, police were called. The suspect was on the scene, and the firearm was recovered from his waistband. I believe the victim, Ms. Charlotte Fontillas, is here. If she would like to address the court, I would like the court to sound for her at the appropriate time, but we have had contact with the victim. She is fearful. She has reported to our office. This is not the first time that he has put out a gun on her and her children. He has threatened to kill her and himself in front of the children. So based on the facts of this case, the victim being fearful and a handgun being involved and children being involved, we are asking that the $10,000 surety bond remain as said.
Mr. Dodes?
Yes, Your Honor. Mr. Burns is 31 years old, and he's currently being held on a $10,000 surety bond that he cannot afford. He's been sitting in the Fulton County Jail for the past 15 days, unable to afford this. He is not a flight risk. He's been in Georgia for the last 2 years and has a stable address, which I'm happy to provide in the chat. He has family in the Nashville area that I've been in contact with. He also has his local church bishop, who I was able to call yesterday, Mr. Christian Samuel. He has one child with the alleged victim, and he's clear that if he's granted a bond, that he can get out if he can have no further contact with that child or the alleged victim. Was very clear on that, and he understands the consequences of violating that. He's currently taking classes at Southern New Hampshire University, focused in psychology. He's currently trying to get on disability for various issues that he's trying to apply for. Again, he knows he can have no further contact, but he can't afford any amount of bond. So after speaking with Mr. Burns, we would request a signature bond.
Your Honor, I'm sorry.
Okay,
I don't-
Mr. Walker, I'm not gonna grant a signature bond and I'm not going to lower this bond. I feel that it's fair and reasonable. I'm sorry, I didn't mean to interrupt you, but, okay, I've made my decision on that. Good luck to you, Mr. Burns.
Thank you, Your Honor. That's not Mr. Burns.
Next, Your Honor, we're gonna go to position 1. Mr. Adams, Entrell Adams, he's position 1 and 2.
Okay, and is Mr. Walsh on with us?
Judge, Mr. Walsh sent over a conflict letter late yesterday evening. He has a conflict this morning. From understanding, he said he requested this case to be before the original judge for a trial. Because he had waived the arraignment and he thought he was going to get a jury trial. But from understanding, he's not going to be present this morning.
Okay,
And also, Your Honor, I don't believe that the defendant is being held on these charges either.
okay, if you'll have Mr. Walsh file a formal waiver of arraignment, we'll return the case to the division judge.
He has
and-
already did that, Judge. That's what
Okay.
you understand why it was on this calendar. He had already
Okay.
did that.
Thank you, Ms. Lewis. Mr. Adams, your case is going to be returned to the division judge and you'll get notification of your next hearing date. All right, good luck to you, sir.
Next, we have add-on 6, Mr. Justin Pulley.
This is going to be an arraignment.
Your Honor, it turns out, I was just speaking with Mr. Pulley. I'd like to change my announcement to asking for a 1-week reset. There is a mandated program on another case, and there's also another attorney I've been trying to get hold of. And if I can get the facts down in detail on that, I'd be presenting something else. I'd like to ask to reset this 1 week or 2 at the most.
Okay, so it's up to you. Good morning, Mr. McLean. If you want to reset it for next Thursday, that's fine with the court. If you want to reset it for the Thursday after that, that's whichever you prefer.
Let's shoot for this. Let's shoot for 1 week, and if necessary, I'll ask to delay again. But he is outsourced to Cobb Jail, so I didn't drive up to Cobb County yet. But we will get the details of this program from the other attorney, and I probably won't have to make that journey.
Okay,
One
so we'll
week.
reset this for next Thursday. I think that's 3/9.
That's right. Thank you.
Okay,
Very good.
good luck to you, Mr. Pulley. We'll see you next week.
Thank you, Honor.
Next, we have position number 27, Mr. Ari Ratliff.
Your Honor, that's a not guilty. We're going to waive formal reading of the accusation. Ask the court to arraign him real quick.
Okay,
This is not keeping him in jail. It's not on his booking sheet.
good morning, Mr. Ratliff. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down, Mr. Ratliff. You've been charged in case 21 CR 002104Y with simple assault family violence. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, Mr. McLean, that you're going to waive formal reading of the accusation. Is that correct?
Correct.
How do you plead, Mr. Ratliff? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Next, Your Honor, we have Mr. Nicholas Marcus. He's add-on position 5.
That is also a not guilty, waive formal reading of the accusation. Asked to
Okay. Good morning, Mr. Marcus. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down, sir. Mr. Marcus, you've been charged in case 23 CR 0000805F with criminal trespass. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding that you're going to waive formal reading of the accusation. Is that correct, Mr. McLean?
It is, yes, Your Honor.
How do you plead, Mr. Marcus? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you.
Next, Your
Your
Honor.
Honor, I know that was just a arraignment, but I do want to acknowledge that the victim, Cesar Gutierrez, is on the line this morning as well for that case. So,
Okay.
you can get an excuse.
Thank you. Good morning, Mr. Gutierrez. There's been a not guilty plea in the case. The case is going to be returned to the division judge, and you will be in touch with the solicitor's office, and they'll let you know when the next hearing date is if you'd like to appear. So, okay.
Yes, I just have a quick question about the probation officers and how the probation system will work. Is there any way we can work with him on this? Because this is the third time or the second time he has violated probation. We just
Okay,
want
why don't you, if you will contact Mr. Walker's office, the solicitor's office, later today, I'm sure that they will assist you with your request, sir.
Okay, thanks.
All right, have a good day, sir.
You too.
Thank you. Thank you, Mr. Walker. Who do we have next?
Next, we have position number 28, Mr. Charles Redding.
Your Honor, today, I've had that down for announcement, to be announced. Today, we'd like to plead not guilty, waive the formal reading of the accusation, and arraign him today.
Okay, good morning, Mr. Redding. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down, Mr. Redding. You've been charged in case 23 CR 0000966F with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding that you're going to like to waive formal reading of the accusation, Mr. McLean.
That's correct, Your Honor. Thank you.
Mr. Redding, how do you plead, guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
Next, Your Honor, we have position number 30, Mr. Preston Roberts.
This is going to be a non-negotiated plea.
It is, Your Honor. The only issue is whether or not to have up to 9 days of extra jail time. But because it's unnegotiated, the state, of course, is free to ask for what it wants.
Okay. Good morning, Mr. Roberts. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Miss Jackson, do you have Mr. Roberts's history for me, please?
Yes, Your Honor, the defendant has 25 cycles. The defendant's last arrest was January the 22nd, 2019 for a probation violation. And if I could have just a moment to scroll down and look at the GCIC and see if there are any convictions for you. I do see a misdemeanor conviction that was in 2018 for criminal trespassing. I'm still scrolling through them. It's an additional probation violation that was on 2015. I do see another misdemeanor conviction that was in 2013 out of Gwinnett County for forgery in the 4th degree. I do see an additional misdemeanor conviction that was in 2012 for theft by receiving stolen property. It's an additional misdemeanor conviction that was in 2011 for battery.
Okay, thank you, Ms. Jackson. I appreciate
Yes,
it.
sir.
Good morning, Ms. Bickerstaff.
Good morning, Judge. How are you?
I'm doing well, thank you.
Yes, Your Honor. So the defendant on February 17th entered the 5 Points convenience store attempting to buy some cigarettes. And then after getting into a dispute with the clerk over the purchase and the payment of the cigarettes, the defendant became irate and he just stormed out of the convenience store. And then when officers arrived to that location to de-escalate the dispute, the officer saw the defendant reaching in his bag. He grabbed a drink out of his bag and he threw it at the door. And then the defendant began striking the door and he became angry and he caused the door to separate from the building frame. And he also caused damage to the hinges on the door. And also, Your Honor, the glass partition on the door became dislodged from the frame itself, from the door itself. And so for these reasons, Your Honor, our recommendation of $1,000 surety bond and to stay away from that 5 Points convenience store at 20 Broad Street Southwest stands.
Okay, it's my understanding this is going to be a non-negotiated plea. What is the state's recommendation?
Oh, I'm sorry, Your Honor. So our recommendation is 12 months to serve 45 days, credit for time served 14 days, the balance probated, and a stay away order from the convenience store at 5 Points, 20 Broad Street. And we're also recommending a 6-week anger management course.
Okay, thank you. Mr. McLean?
Your Honor, he's been in 14 days, I believe, as of today. He certainly agrees that he needs to take and wants to take the anger management course, whether it be 6 hours or 8 hours. He's pretty flexible on it, but he is remorseful. He recognizes he was having a really bad day and acted inappropriately and apologizes for that. And he's asking to get time served, which would be 0 extra days instead of 9 extra days. He feels that being in 14 days, he's ready for the anger management class. He's going to stay away from that location. I noticed there was a gap of several years since the last arrest. And that's our point, simply that he's already gotten the point.
Okay. Mr. Roberts, it's my understanding that in case 23 CR 0000967G, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I do, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Mr. Roberts. The sentence from the court is going to be 12 months to serve, 28 days, credit for time served, 14 days. The balance is going to be probated. You're to stay away from the 5 Points convenience store located at 20 Broad Street, 6 weeks of anger management. I'm going to require that you are on probation for the entire 12 months, but I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet, okay?
Thank you, sir.
All right. Good luck to you, Mr. Roberts.
Next we have,
Position number 11, positions head on 1 and 2, last name Palmer.
Okay. And did you say this is position 11?
11 and 12, and then add on 1 and 2.
Okay.
I have this conflict attorney,
Right,
Ms. Bell.
Yeah, it is Ms. McLeod. I'm sorry for interrupting. She was called in for jury trial before Judge Edie, she indicated that the defendant will be taking a plea. She said she will get on, hopefully she could resolve this matter quickly this morning, and she will get on as soon as possible. If any other changes, she will email me and let me know.
Okay.
Just hold for her report, I guess.
All right, thank you. So we'll have to come back to Christian Chambers. Who do we have next?
Next, we have position number 25, Mr. Pierce.
This is also a non-negotiated plea.
It is, Your Honor.
Good morning, Mr. Pierce. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Does he have a history, Ms. Jackson?
The defendant has 39 cycles. The defendant's last arrest was December 14th, 2022 with the City of Atlanta Police Department for criminal trespassing and obstruction of an officer and disorderly conduct and terroristic threats act. The defendant does appear to have an open case pending in DeKalb County for criminal trespassing. And the defendant appeared to have an additional open case pending in Fulton County for possession and use of drug-related objects.
And where is that pending?
That appeared to be in Fulton County. There was no case number provided for that charge, Your Honor, but the defendant does appear to be on probation for theft by taking a misdemeanor. That case number is 22 CR 00901 and a letter C. That disposition date is March 8th, 2022. 32 days of confinement and 12 months of probation. The defendant appeared to have an additional open probation case in Fulton County for fair evasion and criminal trespassing and obstruction of an officer. That case number is 22 CR 0040005 and a letter H. That disposition date is July 7th, 2022. The term is for 12 months. And the defendant does appear to have an additional open probation case for a P&I. That case number is 22 CR 003290 and a letter Y. That disposition date is June 7th, 2022. The term is for 12 months. And there's another open probation case in Fulton County for obstruction of an officer. And that case number is 19 SC 172946. That disposition date was January 14th, 2020. 1 year of confinement and 4 years of probation. And the defendant appeared to have an open probation case in Clayton County for criminal trespassing and terroristic threats act. That disposition date was January 17th, 2023. 90 days of confinement and 12 months of probation. Nothing in addition, Your Honor.
Okay. Do we know anything about this possible open possession of and use of drug-related objects, Ms. Campbell?
I can look into it. It's not on today's calendar, but if you want me to look at it, I can.
If
you want to resolve both matters at the same time.
Right, that's what I'm thinking. Mr. McLean, if he does have another open state court case, I would imagine that you'd probably want to get those resolved at the same time, wouldn't you?
I agree, Your Honor. And his is an unusual request in an unnegotiated plea in that he was talking to me about asking the court for a certain number of extra jail days while he gets back together on several matters. He's applying to this program called Inspire, and he's trying to set up his rehab. And so a 1 week reset or getting it together today on the other case, either way would work.
Why don't we reset it 1 week to give everybody the opportunity to look into it? And if he is trying to get into a program and he gets into the program, the court might take that into consideration regarding the sentence. Okay.
Thank you, Your Honor.
All right, so I am on the SAP calendar next Thursday, so let's reset him for next Thursday to be back before me, okay?
Yes, Your Honor.
Okay, and Miss
Anybody know what
Campbell,
excuse me, Judge, anybody know what the case number is supposed to be, the open case? Because I'm not seeing one.
I'm not, I was not provided with the case number.
okay, well, hopefully the week will give everyone enough time to see if there is an open case, and if there's not, then we could just proceed on this matter next week. All right, who do we have next?
Next, Your Honor, we have position number 33, Mr. Tony White.
We got position number 22 and 23, Palmer. Jail iPhone.
Okay, sorry, Norris.
Your Honor, you can go to the jail iPhone.
Okay, all right,
No.
thank you. Let's see, 22 and 23. This is gonna be an arraignment. Is that right?
Yes, Your Honor, that would be an arraignment.
Okay, good morning, Mr. Palmer. Can you hear me okay? Yes? Is this Mr. Palmer on the iPhone? Can you hear me?
That is Mr. Palmer there.
Okay, can you speak for me, Mr. Palmer, so I can hear you?
Yes, sir, I can hear you.
Okay, very good. Mr. Palmer, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Palmer, you've been charged in case 22 CR 004314C with battery family violence, and in case 23 CR 000922C with battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Mr. McLean?
We do, Your Honor.
How do you plead, Mr. Palmer? Guilty or not guilty?
Yes.
That was a not guilty, correct?
Yes, sir.
Okay, your case will, your not guilty plea is noted. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir. All right. Okay, courtroom 2. Who do we have?
33, Mr. Tony White, position 33.
Okay, this is a negotiated plea.
It is.
Good morning, Mr. White. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. White. Ms. Bickerstaff.
Yes, the state's recommendation is 12 months to serve, 34 days. Credit for time served, 17 days, balance probated, a 6-week anger management course, and no further contact with LaShonda Davis, and a stay away order at the location 55 MLK Drive, Atlanta, Georgia.
Mr. McLean.
Those are the terms he expected to hear, and he stipulates the necessary elements, Your Honor. And ask the court to accept his negotiated plea of guilty.
Mr. White, it's my understanding that in case 23 CR 000917F, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'm going to accept the plea as negotiated. Mr. White, I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, sir.
Good luck.
Thank you, Your Honor.
Next, Your Honor, we have position number 26, Mr. Davon Price.
Okay. And who's representing Mr. Price today?
I believe this is a conflict and it's.
That's
Attorney
Ms. McLeod's case also.
Okay, so Ms. McLeod is not on with us right now. Can we get Mr. Price, your counsel is not with us at the present time. We're going to hold for her announcements, and so hopefully we can take your case up a little bit later, okay?
That's all I have in courtroom two, Your Honor.
Tell me who we have again?
I said, that's all I have in courtroom two.
Oh, okay. Do we have any other courtrooms or locations?
ACDC didn't log on yet? Give me 1 second, Your Honor. Let me make a phone call.
Okay, thank you.
Good morning, Judge. This is Rose Woodbury from the Public Defender's Office. My client, Brittany Fagan, was on the add-on calendar, position number 3.
Okay.
We are requesting a 1-week reset today. We thought we had a negotiation that fell through at 6 p.m. last night, and we are going to need additional time to continue to negotiate this case.
Good morning,
Okay.
Judge. How are you?
Good morning, Ms. Jenks. How are you?
Good. It's great to see you.
You also. Okay, so that's fine with me. Reset for next Thursday, 3/9. Ms.
Yes,
Woodbury?
please.
Okay, all right. So that's fine with the court. I'm on that calendar, so I'll see you all back then.
Perfect.
If nothing further.
Okay. All right.
Okay?
Have a great
All right.
week.
Yeah. do
Thank
the
you,
same.
Judge.
Thanks.
Excuse me, sir. May I say something, please?
Yes, who's speaking?
My name is Gail Chambers. I am Christian Chambers' mom and power of attorney. And there are some things on these cases that need to be well noted and put on the record.
Okay, hold on, Ms. Chambers. Good morning. We are how are you related to Mr. Chris? Is it Christian Chambers?
Yes, I'm his mother and his power of attorney.
Okay, so his lawyer will be with us hopefully a little later. She is, I was told she's on trial, but she's going to try to make this court hearing this morning. So if you can hold your comments until we can have your son's attorney present. At that point in time, if you would like to address the court, I'm happy to hear from you. I'll have to swear you in, but I'll be happy to hear whatever you would like to tell the court this morning. But we'll have to wait till your son is actually before the court.
Okay, can you tell me who the attorney is, please?
Her name is it's Miss McLeod, McLeod.
Okay, Miss McLeod.
And you'll be able to get her information once she joins us.
Can you tell me, are they trying to make him make a plea?
I don't know, ma'am. So.
Okay.
Okay. All right. So we'll be with you. Thank you, ma'am.
Your Honor, 4 North is about to log on, okay?
Okay, thank you.
All right. Your Honor, I know we have, the competency calendar a little later, but I have Mr. James Sidney James. It's out the courtroom now, department 2. And
Okay,
the competency, he's position 11, 12, 13.
I don't think Mr. Howard is here, but I'll be glad to
Well,
see.
he's here, he's here.
Oh, Mr. Howard is? Okay.
Yes, he
I'm
is.
sorry.
And he tried to speak to Mr. James. He can probably get into it a little bit more than I can.
Okay.
Step on up, Mr. Howard.
Good morning, Judge.
good morning. How you doing today, Mr. Howard?
I'm great, Judge. Yes, Mr. James wants to address the court himself. He doesn't want to speak with me, so we just ask the court, I guess, to let him.
And
He wishes to tell you.
he is on the competency calendar, and unfortunately, I'm not familiar with his case. Is this something that we need to first speak about in a breakout room?
Yes, Judge, I can jump on. and we can-
Okay, so I think that would be best instead of speaking about this in open court, but I will, you know. if-
We're gonna have open court.
Okay, so I have 4 North with me now, so let me go
Okay.
back to 4 North and
Okay,
then
Your
I'll come back to the competency calendar. Who do we have at 4 North?
We was waiting on McLeod. I think that's who's representing him.
Okay, right, now, Ms. McLeod is still not with us. Can we send her a text or something to maybe get an idea of, Ms. Lewis, of when she's going to try to jump on?
Yes, sir, I'll do it.
And Miss Lewis, I'm sorry, what courtroom did you say she was in? I might be able to.
She's in Judge Edie.
Okay, let me contact the solicitor in that courtroom to see if they can get a hold of her as well.
Okay, thank you, Mr. Walker.
Okay, so I reached out to the solicitor in Edie, and she said they are in the middle of a plea, so Miss McLeod may be a moment.
Okay. And 4 North, do you have anyone else that we can take there? We still have a number of positions on our calendar this morning that we have not taken up yet.
Well, actually, I can go down to 3 South and I just come back up here because he's the only person up here. And then
Okay.
We got an officer going up to 7 North right now.
Okay, thank you.
Your Honor,
Yes.
Mr. Sidney James would like to address the court, and I need to get him out my courtroom.
All right, Mr. Walker, Mr. Howard, what's your,
I thought we were gonna do a breakout first, but whatever the court's pleasure,
where's Mr. Howard?
That's already doing represented. Y'all will learn about law today. Violation of the Constitution and stuff, you know what I'm saying? And show me some proof of delegation authority, like I said in my paperwork, that's the file with the record. Put everything, put on the record for the Hague Convention, World Military Court. You know what I'm saying? But y'all ain't violating y'all oath, y'all under maritime law, y'all ain't operating.
You gotta let the judge talk, Sidney.
I just had to put it out there.
Okay, I understand you, Mr. James. So we'll have discussion. Mr. James has been given the opportunity to address the court, which he's done this morning.
No, I ain't addressing, you know, say you could, you know, let me break it. Your Honor, you finished? You took an oath on the Constitution. You took an oath on the Constitutional, right?
Mr. Howard, are you with me? You're on mute.
Yes, Judge, we can do the breakout.
Okay, all right. I've already dismissed Mr. James.
Okay, so we can just talk about it on the regular competency calendar breakout, Judge, if he's gone.
Okay, yes. All right, so
and I'm sorry, Your Honor, I see Mr. Ray back. I think he was here for his son, but his son's case was reset.
Did you have a question? Did you have a question, additional question, Mr. Ray?
Yes, I did, Your Honor. I was gonna wait till after the last case to approach the bench again and ask you a question, if possible.
Okay, go ahead. I'm not sure if I can answer it, but I'll try to direct you to who can if I can. Go ahead.
Well, I wanted to know, in light of my son's injuries, I wanted to know, was it possible that he be released into my care on at this time, and on Tuesday we can address these bond issues? Because I would really like my son to be out so he can get the proper care, if possible.
Okay, and I'm sorry, Mr. Walker, can you tell me who we're speaking of again?
Let me look at my notes.
Position number 3.
This is position 3, Mr. Anderson.
So it's position 3. He has a juvenile hold out of DeKalb, so he wouldn't be able to be released either way. I understand he is at Grady, but he has a no bond with a juvenile hold. So
okay.
And I did go over that. My apologies, Your Honor.
No, go ahead.
I went over that with Mr. Antoine, and I know Mr. Ray emailed me his concerns, and I was going to give him a call after this so we could go over everything. So, Mr. Ray, I will try to speak with you after this too.
All right.
All right, very good. And so we will see you back on possibly on Tuesday.
All right, Your Honor.
thank you.
I do see Ms. Dickerson on the Zoom for position 13, Eddie Dickerson. Ms. Dickerson, we resolved your son's case, and I'll give you a call as soon as I get out of court, but I don't want you to have to stick around.
Good morning, Ms. Cloud. I see you there. Can you hear me? You're on mute if you,
Are you waiting for me, sir?
is this Ms. Dickerson speaking?
Yes, sir. I can barely hear you though.
Okay, what were you saying to Ms. Dickerson, Mr. Dodos?
We resolved her son accepted a negotiated plea. And so I don't want her to sit around waiting for something that's already happened. So Ms. Dickerson, you don't need to stay on the line, and I'll give you a call as soon as I leave the courtroom.
Thank you so much.
Okay, thank you.
Okay, bye-bye.
And Your Honor, I see that Ms. McLeod was on. Is she still on?
I think she was having some audio problems, so I think she might have jumped off and maybe she's trying to get back on.
Okay. Well, when she comes back on, this will be position number 26, Mr. Price.
Okay.
Good morning, Your Honor. I can hear you now.
Yes, good morning, Ms. McLeod. Let's see, we have a number of your clients this morning, and I believe that I was told that this is position 26. Mr. Price, have you had an opportunity to speak with Mr. Price?
I have not been able to speak with it yet, Your Honor.
Okay, do you want to go ahead and have you had the opportunity to speak with any of the people that we have on the calendar today?
No, Your Honor.
Okay, so we
Not
have
yet.
Mr. Price in courtroom 2. So why don't we, do you have the ability to go ahead and call courtroom 2?
I'll give Ms. McLeod a call, Your Honor.
Okay,
Thank
thank
you.
you. And I see that we have 3 South on. Who do we have at 3 South?
Mr. Owens, position number 21.
Okay. This is going to be.
That's a negotiated plea, yes.
Okay. Good morning, Mr. Owens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Campbell?
Yes, Your Honor. The state's recommendation is 12 months to serve 26 days. Credit for the time he's already served 13 days. The balance is to be suspended and he's to stay away from the incident location, which is 7860 Sonoya Road in Fairburn. Nothing further.
Yes, Mr. McLean.
Nothing further from the defense. He does ask the court to accept his negotiated plea of guilty. We stipulate the 3 necessary elements, and that is what we expected to hear.
Okay. Mr. Owens, it's my understanding that in case 23 CR 0009660A, you wish to plead guilty to theft by shoplifting. Is that correct?
Correct, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir. Just woke up.
You've been represented by counsel. Are you satisfied with his representation?
I am very much so.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Owens. Good luck to you, sir.
Thank you, sir.
Judge, tell Ms. McLeod, give me a moment. I gotta go back up to the fourth floor to grab Mr. Chambers.
Okay, and she's on with another client right now, so we'll have her speak with, she's gonna need to speak with him this morning also.
Okay, all right. Can I get
Okay.
McLeod's phone number?
I don't,
It's 404
Okay,
457
okay.
2195.
Thank you.
You got it.
all right, and I see that we have Joe Court's iPhone on. Who do we have?
Position 14, Mr. Goodrum.
Okay. And this is going to be an arraignment?
Yes, Your Honor. And we, after speaking with Mr. Goodrum, will waive formal reading.
Morning, Mr. Goodrum. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Goodrum, you've been charged in case 22 CR 004162Y with obstruction of law enforcement officer. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, counsel, that you're waiving formal reading of the accusation. Is that correct?
Yes, Your Honor.
How do you plead, Mr. Goodrum? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Thank you. Have a good day.
Your Honor, whenever you're ready, we got Mr. Price and Ms. McLeod ready to go.
Thank you.
Think she has to log back in again.
I think she's on her phone, so.
It kicks you out rapidly to let you back in. What should we do? I think so.
Yes, you go. Remember how I said time and usually be wide.
Yeah.
J and E are in.
Are you with us, Ms. McLeod?
I am.
Okay, and what are we gonna do with Mr. Price today?
He is interested in accepting the state's time served offer, Your Honor.
Okay,
I don't believe the offer was time served.
Well, he's been in there now for more than a year.
But not on this case.
Okay, I understand.
how much time is he receiving on this matter, Ms. Campbell?
He's only served 45 days on this case. It just happened. This happened while he was in the jail on serious felony charges. And the state's offer was 365 days.
Ms. McLeod?
Yes, Your Honor. What he says he's coming up for a hearing in May, Your Honor. And based on what the state offered, just 65 days. And even saying he's already spent 40 days, the 2-for-1 would take him up to May. I would say he doesn't want to be in there longer than May in case he doesn't get out. In case he gets out on his other charges, he doesn't want this case to be holding him up.
Okay, well, I mean, if it's only May and it's really 365 days, he would be in longer than May, correct? With this, if he pleads guilty and accepts the 365 days. Am I wrong about that?
My math is not that good, Your Honor. I thought that they would have run it based on the fact that he was already in jail for such a long time. He's been in for quite some time. And this is, after all, a misdemeanor. I'm sure the court knows the facts of what happened. The alleged victim, based on my understanding, didn't want him to be over-punished for this.
But she's not.
Okay, I would feel more comfortable, Ms. McLeod, if we reset this until next week to give you the opportunity.
And that's fine with me, Your Honor, because he.
Right, so we don't have to take this plea
He wasn't there under that.
Okay, so I'm gonna reset this up to give you the opportunity to really inform him what he's pleading to and how long he's gonna actually be in if he takes the offer. So we'll reset it till next Thursday, 3/9. Is that fine with you, Ms. McLeod? Okay, you're on mute again, Ms. McLeod. You're on mute, Ms. McLeod.
Yes, I have another client on the calendar who I need to speak to, Christian Chambers.
Yes, and we're gonna reset Mr. Price until next Thursday.
That would be fine, Your Honor.
Okay.
And I apologize to the court because I was called in to Judge Eda this morning.
Yes, we received that announcement. Yeah, so we understand. So I'll see you back next week, Mr. Price. Okay, so Christian Chambers is at 4 North. I think you'll have to speak, they'll have to call you, Ms. McLeod. I want you to also know that his mother is on the line and his mother wants to participate.
She can always call me, Your Honor. She has my number.
Oh, okay. All right.
Well, I gave it to her some time ago. She and I have had extensive conversations in the past. So she
Okay.
should have my number.
Okay, very good. So if we can get 4 North to call Ms. McLeod, I guess.
Seven.
Thank you, Your Honor.
Judge, are they the only one in 4 North? Do they want to go in a breakout room?
You want, Ms. McLeod, would you prefer to go into a breakout
A
room?
breakout room would be best, Your Honor. Yes.
Okay, all right. So let's put them in a breakout room. Thank you.
Including his mother in there or not?
Do you want the mother?
I do not, Your Honor.
Okay, so
Mr.
not at this
Chambers is an
time.
adult.
Okay.
Excuse me, Your Honor, I've had one conversation with Ms. McLeod where I have tried to inform her of the situation and the lack of service, the lack of process of service, where she was not willing to hear the fact that we've never received any hearings on this matter, and she wanted to just summons my son over the phone. At the same time, these cases have been initiated by a racist individual that has been manipulating the system and doing illegal actions against our family and harassing our family, and then initiating cases and trying to play the victim, where we had to get a TPO against this individual. And this case was sitting dormant for a year, which is also another violation of my son's rights. And these cases are also been submitted already for investigation due to the violations that have happened. And there's documents that should be on the case that should be reviewed. And we're also requesting everyone's assumed name, credentials, and W-9s, and everything else on the cases.
Okay, Ms. Chambers. So let Ms. McLeod speak to her client, who is, my understanding, is of age, and she is representing him in this matter. Okay, so let's go ahead and put them into a breakout room so that they can discuss the matter. Thank you, Ms. Chambers. We'll be with you. Mr. Cohen, do you have business before the court this morning?
Yes, Your Honor. I had Antrell Adams on this calendar, and I'm sorry, I had 2 Superior Court matters, one with Judge Fluker and Gwinnett, and the other with Judge Mason. And
no, you're fine. Tell me who your client is again.
Antrell Adams, Your Honor.
They were
Okay, it's my understanding.
one and two, Judge.
Right. It's my understanding that you filed a waiver in the matter, so we have returned the case to the division judge. As I understand that you'd already filed a waiver of arraignment. Is that right?
That is correct, Judge. And I believe is this Judge Besson's division or?
What is why? Mr. Walker?
Judge Edie. It's Judge Edie.
Judge Edie. Okay. Thank you, Your Honor.
Okay. All right. Thank you. We appreciate you being here this morning.
No, thank you.
Okay. Have a good day.
You too.
Excuse me, sir, can I also submit to the court that Christian Chambers also signed a power of attorney?
Hold up, Ms. Chambers. I cannot do anything on your son's case unless your son, his attorney, and the state is with us, okay? So again, I'm happy to let you speak at the appropriate time. I'm not even sure what we're going to do with your son this morning in regards to any of these charges. So just give me a moment so that I can adequately be informed by counsel as to what's going on. And if you would like a chance to speak at that point in time, I'm happy to give you that opportunity, okay?
Okay. It's just that he feels very uncomfortable in this situation. He feels intimidated by these individuals and they're coercing him.
All right. We'll be in recess until counsel comes back. Ms. Lewis, are you with me?
Yes, sir, I am.
Does that I have that after we complete these two, that we've completed the calendar. Is that go along with calendars?
I'm still missing I'm looking now, combing through. It looks about it. I still need announcement on a couple of them. I just want to clarify some of the announcements.
Position 31, there's a conflict attorney. Is that also Miss McLeod?
Yes, that is.
Okay, so she has another person that she's going to have to.
And did we address position 14, Goodrum?
Yes, we already took a plea on that.
That was, I believe.
I mean, that was a rain, I'm sorry.
Okay.
And let's see, is Nora still in the courtroom?
He's walking over.
Okay, I just want to know, we still have position 31, Ryan, that's Miss McLeod's case also, are we trying to pull him?
First name Rodelius.
Yes,
Yeah, he's on the 7th floor. I'm just waiting for him to go there.
Okay, thank you.
Okay.
And I think that I think that's the last one after Miss McLeod speaks with who she's with now.
Okay.
And I just want to clarify with the PD for positions 17, 18, and 19. Do y'all have a particular date, or do you just want me to set it as appropriate that it needs to be reset to for the competency calendar?
You can set it as appropriately. This isn't what's holding him.
Okay, or were y'all filing any of any MHT on it? I mean, MHT on it?
We already did an eval in a Superior Court for one of his cases. I was gonna get that paperwork. Do I need to also file one separate for this case?
Yes, you do, because that's totally different cases.
That's
So
what I wanted to make sure. And I'll submit all that paperwork. Just wanted some clarity on that. Thank you.
Okay, that's fine. So if that's the case, we have to wait for it. I'll just set it out 4 weeks. We'll set it towards the end of March. Hopefully we'll have that eval back.
Perfect. Thank you.
It'll be March the 23rd for all his cases.
And I'll get all that paperwork to you as soon as I get out of here, Ms. Lewis.
It's no problem. Also, I need some null pros for a case. So if y'all have the null pros ready, can y'all please make sure you email it to me in a timely manner? So it won't hold up my paperwork processing. For any ASG who null pros.
Yes, ma'am.
Thank you, sir.
Of course.
Mr. Doty, can you hear me? Is Mr. McLean in the courtroom with you?
He's right next to me.
Mr. McLean, you made an announcement on number 29. You need to file one, or one has already been, I don't see one has already been issued on position number 29.
I'm gonna get with my social worker who interviewed her yesterday and find out how extreme it is.
So right now, do you want it on a competency counter, or you just want to reset it to a week out?
Yeah, I just need to ask her if it needs to go to a competency calendar or not.
So do you want to wait a week out? To
Yeah,
next Thursday?
so that'll be fine.
Okay. Ms. McLeod, you also know you have another client on the calendar. I don't know if you're aware of that. Position number 31, Mr. Ryan, you recall? Remember how we talked about him before?
Yes, I remember that.
Okay.
I haven't spoken to him yet, but I will speak to him. Your Honor, may I address the court on this issue?
Yes, please.
Your Honor, my client does not have his own phone. He does not have his own address, and it has been impossible in the several months I've been representing him to have communication with him outside of his mother. And because of that, we have not been able to resolve anything. When I try negotiating with the prosecutors, Mom is always there running interference. In last December, when he had a court date, and I knew he had a court date, and I called Mom and I informed her that there was a court date, she refused. She told me point blank that she would not have him in court. And I explained to her that there will be an FTA if he did not show up. She said she didn't care. In the days leading up to the court, I text her every day. And I tried calling her. She did not answer any of my calls or respond to any of my texts. As a result, my client is now in jail.
Okay. And what do we propose to do with Mr. Chambers today?
Well, the state doesn't have an offer on him based on what I saw, Your Honor.
We have an offer.
I don't. What is your offer?
I can read it onto the record. Just give me 1 second. Let me get the counter pulled up.
Okay, and let me just start from the top, Mr. Walker, on this.
Yes, Your Honor.
And I don't know anything about this case thus far. Good morning again, Mr. Chambers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Let's see, Mr. Chambers, you have been charged in case 22 CR 001844D with 3 counts of obstruction of a law enforcement officer, and in case 22 CR 005041D with simple battery. You also have 2 failure to appears regarding these cases. Mr. Walker?
Yeah, so for position 11, the state's offer is going to be 12 months to serve 8 days, credit for time served 4 days, balance probated with the condition of a behavioral health evaluation and any necessary treatment, and a stay away from the incident location. And on position 12, it is 12 months to serve 22 days, credit for time served 11 days, balance probated, 2 weeks anger management, and no further contact with the victim, whose name is Raymond. I will spell the last name Baroldy. In position 11, he was given a signature bond through pretrial release. He FTA'd in front of Judge Edline on 11/14 of last year. On position 12, he was released on a copy of the charges, and he FTA'd in that case as well in front of Judge Edline on 12/1/22. So we have 2 different cases with 2 different FTA dates. He was given a signature bond on one case and through pretrial release at that, and he was released on the charges on the other case, and he appeared neither time.
Okay, Ms. McLeod?
Yes, Your Honor. I don't know exactly if there are any services available for my client because he is a dependent in many ways, although he's an adult, and Mom, she won't allow him to come to court. That's essentially what it is. I have been almost fighting with her for the past several months to get him to show up for court, and she refuses to even tell him the information.
Can I speak,
on
sir?
Zoom.
Oh, yeah, I'm going to allow you to speak in a moment, ma'am.
If it's on Zoom, she won't share the link with him. You know, if it's in person, she tells me absolutely will not be there. I don't know what else to do, Your Honor, quite frankly.
Okay, all right, thank you, Ms. Chambers. I'm going to allow you to speak. I'm going to have you raise your right hand, unmute yourself. You have to unmute yourself for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Now, Ms. Chambers, I don't want you to speak to the facts of the case. that your son has been charged with these offenses. The state is pursuing these charges against him. He has counsel in the matter. He apparently did not show up for court on 2 occasions. Is there something that you want to tell the court in those regards?
Yes, sir. First of all, we have not been receiving any summons, so there's lack of due process because the alleged victim has been stealing the mail, so we never received anything on those cases. I spoke to Ms. McLeod on 1 occasion where I informed her that we had been receiving anything. I have not been purposely not speaking with her. I spoke to her 1 time. She has not called me on so many occasions. I spoke to her 1 time. I have not been purposely not letting my son come to any court dates. We haven't been known about any court dates. The alleged victim in the case has been stealing the mail, and he initiated these cases because he had been harassing our family and doing illegal actions against our whole family, and where we had to initiate a TPO against Mr. Romo, which can be found at case 2021 CV 356379 by Judge Law, where he had actually admitted doing illegal actions in these cases. One of these cases was sitting dormant for a year, which is also a violation of my son's rights. We, like I said, are requesting everyone's assumed names and W-9 credentials in these cases. The cases have already been sent to review. And this is just a lack of process and service all the way around.
So Ms. Chambers, so what you're telling the court is that you want your son to have, it's your request that your son have a jury trial on these charges.
Definitely, jury trial. And we definitely need
correct
process of service.
Listen, if that's going to be your request, he is in custody right now. Okay, so these charges are still pending. If he does get a jury trial on this matter, he has FTA'd in the case. So which means that he failed to appear on his court date. So that's what we're here to address today, these FTAs. All right, so the offer for your son that he'd be done with this is a time served offer. It's my understanding that I don't know what his wishes are, but given that he is FTA'd, the normal practice of this court is to return the case to the division judge so that they can address the failure to appear, which means that your son is going to remain where he is until the division judge, which will be Judge Edie, or it's a Judge Edline, decides whether or not she would like to lift the failure to appear that she has issued in that regard. So I am happy to give him the opportunity to do that. It means that he's going to be here until he gets on a calendar with her. Okay. Now, Ms. McLeod, do you need time to discuss with your client who is of age what he wishes to do in that regard as to whether he himself, not his mother, he himself wants to remain in custody and go back in front of Judge Edline, or whether or not he wants to accept the offer of the state, which is a time served offer, and he would be released from custody as soon as he can get processed out. Would you like to speak with him in that regard?
I would like to speak to him on that, but I also want to confirm with Mr. Walker that is, in fact, the state's offer on it's 2 cases.
It was a behavioral health evaluation and treatment on position 11. And then on position 12, I believe it's 2 weeks anger management and no further contact with the victim. You just pull up the calendar one more time to confirm. Yes, so he will be on probation, behavioral health evaluation, 2 week anger management, no further contact with the victim.
How long is the probation? A year?
Yes, but there's no objections to, once he completes the evaluation, any necessary treatment and the anger management, to non-reporting.
Okay, I'll discuss it with them.
And I think you should also know, Ms. McLeod, I've been told by Ms. Lewis that the total bond amounts to $8,000 surety bond. So if If they can come up with that, then that's an option also.
I will let him know. Your Honor.
Okay, very good. Let's put them into a breakout room again, please.
Yes, sir.
And the court will be in recess until they return. Unless, Mr. Walker, you all want to start I'm not sure if anybody's available for the competency calendar.
If Mr. Howard is here, I'm available.
Do you want to go over the SAP calendar, Judge, or we good on that?
We can do that, Ms. Lewis. That's fine also. Okay, let's go with the SAP calendar since we only have 2 more cases to get resolved this morning.
Okay. All right. I'll start on with the add-on. Add-on 1 and 2 is still pending. Position 3 on the add-on is going to reset for the SAP for March the 9th. Position 4 on the add-on was a plea. Position number 5, the defendant was arraigned. The case is reset for trial further notice. Position number 6 is reset for the SAP for next Thursday, March the 9th. That's the conclusion of the add-on calendar. Going to the original calendar, position number 1 is going to be returned back to the original judge for trial. That's for position 1 and 2. Position number 3 is going to be an add-on for Tuesday SAP calendar, which is March the 7th. Position 4 was released, cases reset further notice. 5 and 6 both were released, cases are reset further notice. Position number 7 was a plea. Position number 8 was a plea. Position number 9 is going to be null pros. Position number 10, defendant waiver arraignment, cases reset for trial further notice. Position number 11 and 12 were still pending for announcement. Position 13 was a plea. Position number 14, defendant was arraigned, the case is reset for trial further notice. Position 15 was a plea. Position number 16, defendant was released, the case is reset further notice. Position 17, 18, and 19 is going to be reset to the competency counter for March the 23rd, pending on eval. Position number 20 was a plea. Position 21 was a plea. Position 22 and 23, both were arraigned, not guilty. The case is reset for trial further notice. Position 24, defendant was released. The case is reset further notice. Position 25 is going to be reset for the next SAP counter for March the 9th. Position number 26 is reset also for the SAP for next week, March the 9th. Position number 27, defendant was arraigned. The case is reset for trial further notice. Position 28, same announcement. Case was arraigned, not guilty. The case is reset for trial further notice. Position 29 is going to be set to next Thursday, SAP for March the 9th. Position number 30 was a non-negotiated plea. Position number 31, we're still holding. Ms. McLeod has to talk to her client, she says. Position number 32 was released. The case is reset further notice. Position number 33 was a plea. Any questions or concerns or any corrections?
Thank you.
Your Honor, I was able to discuss all the terms of the plea with my client and to discuss all the rights he'll be giving up if he accepts the plea, all the terms and conditions. And he tells me that he does wish to accept the state offer.
Okay. On both cases?
Yes, Your Honor.
Okay. All right. Let's see, Mr. Walker, anything further?
I can restate the recommendation if the court desires me to.
Why don't we go through the recommendations for both? Thank you.
Just 1 second. On position 11, the state's recommendation is 12 months to serve, 8 days, credit for time served, 4 days, balance probated with conditions of a behavioral health evaluation and any necessary treatment. Also with the conditions of a stay away from the address of 3085 Creel, Creel Road, located in South Fulton. On position 12, it's going to be 12 months to serve, 22 days, credit for time served 11 days, balance probated with conditions of a 2-week anger management course and no further contact with the victim, whose first name is Raymond, last name is Baroldy.
Okay, Ms. McLeod?
Yes, Your Honor. Those are the terms as I understand them.
Okay. Mr. Chambers, I'm not sure if I've sworn you in, so let me make sure that I do that. Can you raise your right hand for me? The other right hand. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Chambers, you've been charged in case 22 CR 001844D with 3 counts of obstruction of a law enforcement officer, which is my understanding you wish to plead guilty to. And in case 22 CR 005041D with simple battery that you wish to plead guilty to. Is that correct?
I thought it was the plea not guilty. Yes, sir.
Okay, so you wish to plead not guilty?
Yes, sir.
Okay. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000.
Hold on. Can I take the 4 days?
Well, it was my understanding. So let me start at the top, Mr. Chambers. If you want to plead not guilty, I'm going to arraign you this morning and record your not guilty plea and return your case to the division judge. If you want to take a plea, you've heard the terms of what the state is offering.
Okay.
Correct?
Yes.
Okay, so if you want to accept their terms, this court is going to accept those terms. And what I would do is while you're on probation, I would waive the probation fees for you. And when you complete the terms of the probation, it would go to a non-reporting status. So those are all the terms of a plea of guilty. So which would you like to do this morning? You've had, just for the record, you've had the opportunity to speak with Ms. McLeod regarding this. We've gone into 2 breakout rooms so that she can discuss the matters with you. I believe that we placed on the record what the terms are. Do you understand what the terms of the guilty plea would be?
Yes.
Okay, and so what do you want to do this morning, Mr. Chambers?
I'll do the 4 days.
Okay, so you don't. So let me just make sure that if nothing's holding you, which I don't think it is, the terms of both these offers is that you are going to be that it's a time served plea, and that as soon as you can be processed out of the jail, you will be processed out. You will be on probation for all of these charges. And on the position 11, the probation would be until you complete a behavioral health evaluation and treatment if necessary. And you'd be on probation for the simple battery until you complete a 2-week anger management. Okay? And then once you complete those, it will go to a non-reporting status. Do you understand the terms of what you would be required to do if you accept a plea?
Yes, sir.
Okay, so given that, what is your desire this morning?
I'll do the one where I can get out as soon as possible.
Okay, so you wish to plead. So you're telling the court that you wish to plead guilty to the charges today?
Yeah.
Okay. So let me start again. It's my understanding that in case 22 CR 001844D, you wish to plead guilty to 3 counts of obstruction of a law enforcement officer. And in case 22 CR 005041D, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
Do you understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes. Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
And you're giving your pleas freely and voluntarily. Is that correct?
Yes, sir.
I will accept the plea as negotiated. Mr. Chambers, as I said I would do, I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it will go to a non-reporting status, okay?
Okay.
And Your
All
Honor,
right.
could you ask my client to put on the record what his contact information is for probation?
Okay.
I don't know. I had to put my sister number on there. I don't know. My sister number on her.
And can we have everything in writing, please? Everything that's non-coercive. He's been coerced.
Ms. Chambers, we've given you the opportunity to speak. Your son is of age in this matter, and of course, everything is always not only on the record, but the paperwork is it will be complete also.
Right, but
Okay.
he's been coerced
Ms.
and
Chambers,
pleading
Ms.
guilty
Ms.
on
Chambers,
innocent
Ms.
charges.
Chambers, would you please mute Ms. Chambers? Okay, thank you. Anything further, Ms. McLeod?
Nothing further, Your Honor. I have asked the mom for the contact information. He doesn't seem to know it. It's all her contact information. She hasn't given it to me. So I don't want him to fail with probation. That's why I asked for it here, Your Honor.
We have the same address as always.
I'll give you my email.
With what?
You need my
Because she
email?
stated, Your Honor, that they have not been getting the court notices. So I want to make sure that.
Your Honor, if I may, Ms. Chambers, do you know how to work the chat feature?
I'm sorry?
Do you know how to work the chat feature on Zoom?
No.
Okay, well, if you look for an option that says chat, if you could select Katrina Lewis and send your address to Miss Lewis, we can make sure your address is correct on the record.
I sent her a text message some time ago asking for it.
Excuse me, Your Honor. If I like to make, can I please give my email, both my emails?
Okay, yes, sir.
Okay, I'll type in chat for you.
Okay, thank you. And Mr. Walker, do you have where the notices were sent?
Yes, proof, please.
I do. It was an East Point address. Let me go back to Odyssey.
And I mean, he should know his address, right?
3675 Marketplace Boulevard,
Is that in East Point, Georgia?
Number 1131.
That's the post office box, Your Honor, just for the record.
Because of Mr. Romo, we're displaced and that's all we have, ma'am. And if they don't put the correct address, we don't get the mail. And I've told her.
Let me just verify that we have, I'm sorry, my Odyssey's going a little slow, but let me just verify we have the correct post office box.
It's 1131. I see it.
You have Miss Lewis?
Yeah, I see it. And also his email, because probation is going to contact him through email. So, let him know when to report and by phone. And I do see two phone numbers in
They
here.
talked him into pleading guilty. She talked him into pleading guilty.
So
They trying to ruin my son's life.
Excuse me. I just need to verify his email address for probation. So probation will have his email address.
I sent both my email addresses in the chat.
Okay, I see. Those are the ones we have on record. Thank you.
Okay, so when we're done with that, Ms. McLeod, I think that we still have one additional person for you to talk with.
Yes, Your Honor. And I'm ready. I can go in the breakout room or I can be called.
Okay, are we completed with Mr. Chambers? Do we know where Mr. Ryan is going to appear this morning?
I'm sorry, is that a defendant or attorney?
Oh, his position number 31.
Oh,
31 is the calendar.
Okay.
Mr. Ryan, who is Miss McLeod's client. I'm just trying to see if we're still trying to raise him.
Use our phone when we're in the jail.
Officer Norton stepped out of the room. I don't know if he's tracking down, but as soon as I see him again, I'll check out.
Okay.
And Judge, also the DV case of defendants on the line too.
How many DBK do you?
We just
I
have
don't
one
have
on
it.
the counter, just one. I sent you a
Okay.
copy of it. You should have it in that package.
Oh, okay.
This was the gentleman that will be set from last time in front of you. He asked for 30 days to hire an attorney.
Right. Let's see. What's his name, Ms. Lewis?
Ms. Kinsey. Mr. Taiwan Kinsey.
Morning, Your Honor. Chris Harris here for Mr. McKenzie. He
Good
has hired.
morning. Yes, good morning, Mr. Harris.
Morning, Your Honor. Yes, I was retained this morning. I had previous conversations with Mr. McKenzie back at last fall, but he's just been able to obtain the funds to retain me. We've already submitted through the e-filing and entry motions and so forth, and are looking to not delay the outcome of this case, but as soon as we can get discovery and dig in a bit, we should be ready.
Okay, it's my understanding that Mr. McKenzie is before the court today because he missed a previous court date, and he had a bench warrant issued for him, and I gave him the opportunity to hire counsel in that regard, so that we could move forward with this matter to see if the bench warrant will be set aside or not. Mr. Walker, can you tell me what, and good morning to you, Mr. McKenzie, also. Can you tell me what court date Mr. McKenzie missed and who that was with?
Yeah, sure. 1 second. So on January 4th of this year, he missed a final plea counter with Judge Besson. I would like to put the court on notice that prior to that, the state had filed a motion to revoke bond due to his continuous contact with the victim. I understand that there is a no further violent contact with the victim, but we have spoken with the victim numerous times, and she has expressed that the defendant keeps reaching out to her, leaving her threatening voicemails, threatening to kill her. At that time, the motion to revoke bond was filed last September. It was never scheduled. However, for his next court date, he did in fact FTA, which a bench warrant was issued, and I believe his bond has since been surrendered. On the cruelty to children charges, it was initially $500 surety bonds on each count, and on the battery family violence, it was a $1,500 surety for a $3,000 surety total. Due to the outstanding motion to revoke bond, the continuous contact, threatening and violent contact with the victim, we ask that this bond or this warrant is not set aside and is addressed in front of Judge Besson to address the outstanding motion to revoke.
Mr. Harris?
Your Honor, I'd say that, I mean, frankly, the bond is expired as is. We ask that he be released on his own recognizance pending a further adjudication on the state's motion, even if it meant refiling. So we could have an opportunity to hear the actual evidence on this. I'm always a little bit wary when I hear things like there's been, there's contact permitted so long as it's not violent or harassing. And to the extent the state's proffering that there is violent or harassing contact, I've not heard of any sort of other attempts to have procured a warrant or any other, terroristic threats charges or anything like that that's been pending or that I'm aware of that's occurred or issued in the meantime, since whenever the motion was filed. So we'd ask that the court based off with the FTA otherwise set in place a signature bond, an owner cognizance bond in the meantime before we can address the actual issues of his continued, I guess, being able to remain out on bond pending the hearing of the state's motion.
And the two other charges, I've got the battery, family violence. What were the two other charges, Mr. Walker?
There was 3 counts of cruelty to children in the 3rd degree, Your Honor.
3 counts?
Yes, Your Honor.
Okay.
500 each. So based on the fact that continuous contact, the state did file a motion to revoke, and then a subsequent FTA in front of Judge Besson, we are asking that the bench warrant remain.
Was it a no further violent contact?
It was, and he's continuously called the victim, threatening to kill her and her family. And that was the basis of the motion to revoke bond, and those were voicemails.
Okay, and in that regard, are are any of these children his?
I will have to review the report to see.
They are, Your Honor.
Speaks to that.
Okay.
And I want to say that it's a no. Let me pull up the original bond order. Well, it was no further violent contact with the victims, but like I said, he since left several voicemails threatening to kill the mother and her parents.
All right, and was a police report made in that regard?
Let me look at the bond. Let me look at the order filed. I'm unaware if a police report was filed, but we do have the voicemails. And again, that is the basis of the revocation that was filed on 9/7 of last year. And then he FTA'd of January of this year.
If I could ask one question, I hate kind of doing this openly, but if Mr. McKenzie can confirm whether or not there's a protective order in place right now, I would appreciate it. Okay.
All right, so I'm gonna allow you to, Mr. Walker, to have your motion to revoke bond. I want to just make a note that Mr. McKenzie has been before this court before. He came initially. I gave him the opportunity, I believe, to hire counsel, which is what he wanted to do. He's done that. He's now represented by counsel. I am going to allow you, of course, to pursue your motion to revoke bond, but at this time, since Mr. McKenzie has been compliant, I am going to set aside the bench warrant. But I do want to put into place a no further contact with, what's the victim's name, Mr. Walker? Alleged victim.
Victim's name is Ronika Nix. Nix, and I can tell you because I want to say the 3 children were also included on the original bond order.
Your Honor, if there's going to be some prohibitions with respect to contact, I'd only ask the court to potentially condition contact ultimately on whatever a superior court may deem as appropriate through civil proceedings involving custody or I'm not sure if this is a divorce technically, but at least custody proceedings. I would hate to have to come back to petition this court for additional relief if the superior court thought that it was appropriate for him to have contact or visitation with his kids.
Well, because this is a criminal matter and the minors are the 3 listed victims, and they were also included on the initial bond order. The state is requesting that they're included on the subsequent bond order. Of course, we didn't provide their name, but there's 3 minors by the age of 11, 9, and 1 years old that were included. That Miss Ronika Nix is the mother of those children as well. And again, she is fearful for her and her children's safety. So we are asking for a no contact based on the information that we have received from our victim.
Okay, that's fine. I'm not disputing the initial, the no contact pursuant to, with respect to this bond, only with the qualification that in the event that some sort of visitation or contact is deemed appropriate by superior court in this jurisdiction regarding custody, that the terms of that, it wouldn't require us to have to come back to amend this particular order to allow that to happen. I believe it's been quite some time since he's been allowed to have visitation with his kids. Okay, and I don't mind you putting that in the order, Mr. Harris. So
So at this point in time, like I said, I will set aside the bond and with the additional requirement that he's to have no further contact with Ms. Nix or the children at this time, except if it's deemed otherwise by the Superior Court. Mr. McKenzie, I want to make sure that you understand what no contact means. No contact means absolutely no contact. It means obviously no personal contact, no email contact, no social media contact. Until this is resolved, no contact with Ms. Nix whatsoever. If you do contact her, you will be in violation of this bond, okay?
Yes, Your Honor, and just for the record, me and Renuka Nitz, I get along just fine. She calls me, let me speak to my son, and we're cordial, been cordial since September.
Okay, so but what I'm telling you now, Mr. McKenzie, is that although you tell me that you're cordial, the state tells me something different. So until this is ironed out, you're to have no contact. You understand me? Okay, yes, and if you do have contact, again, you'll be in violation of this bond. All right, so I'm gonna set it aside because you have been diligent in coming to this court and coming back to this court. I'm going to again, there is a motion to revoke the bond, but at this point in time, I'm going to set aside the bench warrant. Okay, Mr. Harris, can you prepare that for the court?
I can, Your Honor.
Okay.
I was also going to ask if the court's inclined to take up the state's motion, it would be an ideal time to address those additional bond conditions clearly with as been proffered by Mr. McKenzie. Would the court have a date certain as to when that could be heard, or will that just be noticed by the clerk at a later time? I'm unsure.
The case will be returned to the division judge, and she will notice the next hearing.
All right, Your Honor, and I'm assuming that I'll have appropriate emails that I can follow through with respect to contacting the solicitor, Mr. Walker. And should I copy your chambers, Judge Morrow, on the proposed order?
If you will send that proposed order to Ms. Lewis, who is on the line.
Yes, I just send my chat information to you, Mr. Harris.
All right, wonderful.
Right,
Thank
directly.
you.
And Your Honor, just to be clear, you're reissuing the bonds in the same amount as the SOB jail since the previous bonds have already been forfeited?
Yes, with the revised conditions, yes.
Okay.
All right, any additional questions on this morning?
No, Your Honor.
All right, so if you'll get that to us, Mr. Harris, Mr. McKenzie, good luck to you, and y'all have a good day.
Thank you, Judge.
Okay, let's see. Did anyone come back online as far as us getting this last, Mr. Ryan?
Yeah, I'm trying to, I've reached out to the state to find out what their offer is so I can discuss it with my client. And I'm waiting for.
Okay, so while we do that, Ms. McLeod, I am going to see if, since it's 11, a little after 11, I'm going to see if I can go into a breakout room with the competency. Hopefully that will give you enough time to speak with your client, and I'll address him after I address the 11 o'clock.
Fine, thank you.
Okay, all right, thank you. So do we have everyone that needs to go into the breakout room for the competency calendar this morning?
Yes, Judge. I'm here.
Okay, good morning.
I have a client on that, but I think he has two cases, and he has counsel who's going to take over both cases.
Okay, thank you. And so Ms. Lewis, if you can put us into a breakout room, and if you'll keep checking while I'm in the breakout room, if you'll, Ms. Lewis, keep checking with the jail to make sure they bring Mr. Ryan for me.
Good morning. Are we done with probation? Yeah, state on purpose.
Ms. Thomas, we still waiting on position, I think 31. I don't know if it's gonna be a plea or whatnot, so,
I think it is likely to be a plea, but I have not spoken with my client yet.
okay, so, yeah, we still need probation.
No problem.
Okay, thank you.
Ms. McLeod, are you with me? Hear me, Ms. Lewis? Oh. Ms. McLeod? You're on mute.
I'm sorry, Your Honor.
Were you able to speak with Mr. Ryan?
I was not, Your Honor. Apparently he is downtown. They said that he is in a case.
Okay, so do you want to reset this until Tuesday?
Yes, Your Honor, because I see they said there's a message here saying he's in a hearing downtown, a physical hearing, apparently. He's a co-defendant in some other case.
Oh, okay. Okay, all right, so we'll reset. When do you want to reset for?
I believe next Tuesday should be okay.
Okay. Do you think he's gonna be done with that?
I think they say it's a YSL hearing.
Right, so he's probably not gonna be done by next week, right?
Well, it can be set out. I don't mind.
Okay, you just tell me, what do you think?
Let me see, next week, Tuesday is the 7th, and I don't have anything on my calendar that day. Absolutely nothing, which is unusual for me, but I don't.
All right, well, we'll reset it for next Tuesday.
That would
Okay,
be an add-on, Ms. McLeod. I'll
sorry?
count out. I said that would be an add-on counter for Tuesday. With him
Yes,
on there, so
I'll be available on Tuesday.
all right, very good. I think
But I
that's
have
place.
nothing on my calendar. I don't understand that.
Ms. McLeod, question to clarify, was you or Mr. Murphy was gonna take on Mr. Justin Singleton from the?
Mr. Murphy.
Mr. Murphy's gonna be
Yes.
on. Okay, I
Yes.
just want to clarify that. Okay. Thank you.
All right, thank you all. I appreciate it. We'll see you next time.
Judge, I got some paperwork they already sent to me, so I'm about to forward it off.
Okay,
I
I'm
will
still
get it
waiting
signed.
on the paperwork for Christine Chambers.
Do you doing it or is it S?
I'm happy to do it. Nobody has sent me anything, but I can prepare the plea form.
If you could please, Ms. McLeod, I would greatly appreciate it.
I'll do that.
Thank
Do you need me to send you a form or you already have?
No,
one?
I have forms. I have-
Okay.
All right, and I'll send over my null process, right? I'm working on it right now, Ms. Lewis.
Yeah.
And bye, Judge.
All right, have a
Good
good
one.
day. Thank you.